Should we people are still coming in, but maybe we should get started with introductions.
Yeah, absolutely. So just first of all, want to welcome everyone and thank everyone for joining us today for Should I Stay or Should I Go? Implications when a spouse leaves the matrimonial home with family lawyers Michelle Mulchan, Cindy Vergara, and Brittany Whalen. My name is Shannon and I'm part of the community engagement and events team at Russell Alexander Collaborative Family Lawyers. I'm just going to start with a bit of housekeeping. I'll let you know what's on the agenda for today, and I'll be making some introductions before passing the mic over to our panelists. And once I pass things over to our presenters, I'll be available behind the scenes throughout the presentation for any questions or tech issues that may come up. So if you are having any challenges throughout the webinar, please just contact me at shannon@russellalexander.com and I will do my best to help resolve the issue. And I'll make sure to put my email in the chat as well for your reference. And you may notice that the chat has been disabled on your end. And this is just to ensure that everyone's identities remain anonymous throughout the presentation to other audience members. But as I mentioned, if you need to get in touch at all with our team or send in any questions, you can do so through the Q&A or by email. So in this 1-hour presentation, Michelle, Cindy, and Brittany will be sharing their insights on the implications when a spouse leaves the matrimonial home, covering the following topics. Why did the spouse leave? What is the matrimonial home and what about common law couples? Parenting, a new status quo or self-help? Who pays the bills and damaging credit ratings? Post-separation adjustments? Post-separation increases in market value? Return to the home? Exclusive possession, changing the locks and abandoning rights to possession? Occupation rent and limitation periods. We'll also have a dedicated Q&A segment at the end of the webinar. So if you haven't already, please feel free to submit your questions through the Q&A. We have a really great turnout today and we have received quite a few questions already, but we'll do our best to get to as many as we can at that part of the webinar. We also ask that you keep in mind that the content of this webinar is to provide you with general information on separation and divorce and is not to be considered as legal advice. And just one last item before I get to introductions is I just want to mention that I will be sending a follow-up email tomorrow with links to resources on today's topic, along with some other resources on separation and divorce. So without further ado, it's now my pleasure to introduce today's hosts. From the Greater Toronto Area, we have Michelle Mulchan, Cindy Vergara, and Brittany Whalen of Russell Alexander Collaborative Family Lawyers. Cindy is an associate lawyer at our firm where she practices in all areas of family law. Since being called to the bar in Ontario over 10 years ago, Cindy has been practicing exclusively in family law and is passionate about supporting her clients and achieving goals quickly and effectively in a cost-effective manner with the objective of implementing strategies that are unique to her clients and their goals. For instance, after an out-of-court settlement failed, she vigorously advocated and won an international jurisdiction motion wherein a young child will be attending school in Canada as opposed to in a foreign country. Brittany was called to the bar in Ontario in 2016 to the Newfoundland Bar and Labrador Bar in 2017. As a family lawyer, she uses her innovative problem solving and conflict management skills to ensure her clients feel comfortable and supported as she supports them in navigating and resolving their family law matters. Brittany is also known for her minority rights advocacy. She received national attention for her role as lead counsel in a landmark transgender rights case, which led her client to receiving the first gender-neutral birth certificate in Canada. This case acted as a catalyst for countrywide policy and legislative reform aimed at promoting equality, diversity, and inclusion. And lastly, we have Michelle, and Michelle has been practicing family law for over 10 years. She is skilled in all areas of family law, including divorce, custody access, property division, child and spousal support, and family responsibility office enforcement matters. Her focus is on creating comprehensive, creative resolutions to family law matters. Michelle excels at helping clients deal with complex financial issues that arise as a result of a separation. So now that you know a little bit more about our team, I'm going to pass things over to Michelle to get started with the presentation.
Thank you so much, Shannon, and thank you so much for those introductions. We were chatting for a few minutes before the presentation started and said, what a lovely thing to have a group of such wonderful, accomplished women doing this panel, given that it was International Women's Day. So happy International Women's Day to everyone out there. I hope that you were able to celebrate even just a little bit yesterday. So let's jump right in. First, we're going to start with a poll. So the poll question is, what is your reason for joining us at today's webinar? And we just like to ask this because we'd like to, if we can, gear our questions to the people who are attending. Sometimes we have lots of professionals, sometimes we have lots of clients, and we can try to gear our answers a little bit to whoever is attending. I see we have quite a few people attending today, so thank you for joining us on your lunch hour. How are we doing there, Shannon? Have most people been able to vote? There we go. Okay. So family law professional, 50%. That's wonderful. Professional in a different industry who's interested in learning. That's always lovely. We work closely with many different types of professionals. We are so thankful to have you all here. About 22% of you are going through a separation or divorce or know someone who's going through a separation or divorce. And then there's a few others. So we have a pretty good mixed group. Thank you, everyone, and welcome to our session. So that leads us into our first our first slide, which is, why did the spouse leave? And really, I've been doing this for over 12 years. I've seen the gamut of things and reasons why people leave. Really, the most common one, and especially after COVID, COVID was really difficult on a lot of families. The number one reason seems to be that the relationship has broken down. And usually, there isn't one thing or two things, it's many small things. And parties are just ready to live their separate lives. And I don't know if you know this, but we do a lot of collaborative law here. And we here at Russell Alexander's, we really like to resolve things out of court if we can. So our focus is a peaceful resolution. Of course, we do litigation as well. About half my practice is litigation, half is collaborative. So we can do both if need be. So then the second thing we really see a lot of is, unfortunately, people or couples where one party has had criminal charges. And I was telling the ladies just yesterday where I had a call recently where a client called me from jail, and I was very fortunate. We actually have a criminal lawyer on staff. So I was able to liaise with our criminal lawyer, and we were able to get him out pretty quickly, which was quite wonderful. So unfortunately, that happens. I also represent a lot of people whose partners have been charged criminally, and we are well versed in how to deal with that, how to protect our clients, especially where there are domestic violence issues. Another one, and it happens less frequently, is that there's a new partner who is on the scene. And of course, many people call us in a panic because they find out that their spouses are cheating on them. And so at Russell Alexander, we really like to get people in either the next day or at the very worst, the day after. So we try to get people in really quickly so that if you have questions, if something arises out of the blue, you can get to a lawyer pretty quickly to get some initial legal advice. We also see people come in where they've been locked out of the home. And I think Cindy's going to talk about this a lot later on, about what to do if you're locked out and how all of that works. So I won't really go through it, really. And then we have that age-old question of, does it really matter? Well, I will say yes. If they're criminal charges, it really matters. I have just finished doing one of the domestic violence courses. I'll be doing another one to get my certificate soon. And domestic violence, unfortunately, has just gone up. I don't know the newest stats. I don't know that there have been proper polls done on it, but we know that domestic violence is rising as a result of COVID. So if there are criminal charges, it does matter, and it does make a difference. And with, the remainder of the issues, then know it's a standard path and we can help you through it. So that leads me into poll 2, which is, when leaving the home, are common law partners treated differently than married spouses? And so Cindy's going to talk about this, but we'd like to see what you think. And this could be from just your personal opinion or, your best guess. So the answers are yes, no. It depends on the length of the common law relationship. It depends whether or not there are children, or it depends on the ownership of the home. So some really good answers there. And it's really interesting. I'm divided on my answer, actually. So Shannon, do we have enough answers by now? Excellent. Okay, so most of the group believe that the answer is yes, and that's generally correct. There are definitely different rules for common law partners than married spouses, but there are some other items that will also make a difference. And the length of the common law relationship, children, and ownership of the home are all definite things that we need to look at. So as you can see, we wish it were as simple as yes or no. It is not. And we're going to talk a little bit, or actually Cindy's going to talk a little bit about that.
Thank you. Now, the importance of a matrimonial home in the family law context is that this property gets special treatment. So we do want to identify this property early on. Specifically, the matrimonial home is a residence that is ordinarily occupied by the parties. And by parties, I mean a married couple. In some cases, they can be two matrimonial homes. For example, if there's a cottage. In other cases, the matrimonial home, if it's situated on a large piece of land, we can see only a portion of that land being classified as a matrimonial home. Now, once a property is deemed the matrimonial home, the spouses have an additional bundle of rights. For example, there is the entitlement of both spouses having equal rights to possession to the property, regardless of who's on title. There's also financial implications when a property is classified as a matrimonial home, which is not the subject matter of this presentation today. I believe it's the subject matter of the future presentation. So when it comes to common law couples, the situation is different. The home that is ordinarily occupied by a common law couple is not considered a matrimonial home pursuant to the Family Law Act, and they don't have these additional bundle of rights that we just discussed. If a common law partner is a titled owner, then that person has the rights associated with ownership to that property. However, if a common law partner is not a titled owner, the courts allow them to advance claims that they should have a financial interest in the property due to their relationship. We commonly see this come up from our clients in situations where, say, for example, the non-titled partner extensively renovated the property, thinking that they would have an interest in the property if it was ever sold. Another situation is, say, for example, someone pays for all of the expenses on the property, provides a down payment. They would expect that they would receive a contribution at the end if the property was sold. Another time that we see this come up is one party decides to forego their career and stay home and take care of the property, take care of the children, while the other party is able to excel in their career. So when we are faced with situations like this, we work with our clients to help them preserve their rights and advocate for interest in their property. So if you ever find yourself in a situation like this, you should be seeking legal advice, because these claims are very fact specific and evidence driven. So you need someone on your side who can help you navigate this area of law. So now I'm going to pass it on to my colleague, Brittany, for the next slide.
Thank you so much, Cindy. Parenting, very, very important to consider when thinking about leaving the matrimonial home. Please bear in mind that leaving the matrimonial home may affect your ability to possess the home or gain decision-making responsibility and parenting time with your children. If you have children and you move out of the home, you need to be mindful of the fact that you may be creating a new status quo with respect to the parenting arrangements and schedule. That schedule may impact the final parenting order and schedule ordered by the court. That said, we've seen situations where one party will try to dictate the parenting schedule and create a new status quo to gain an advantage in family court. The courts may refuse to uphold a unilaterally imposed parenting arrangement. and generally do not reward parties who resort to self-help measures. So we recommend parties consult with a lawyer to learn more about their rights and obligations as parents and the options available to them as soon as possible, and ideally before making any major moves. A lawyer can also help you establish a temporary parenting plan as you transition into new living arrangements. That brings me to my next slide. Speaking of change in living arrangements, a change in living arrangements may also affect the way that parties share their expenses. When one party leaves the marital home, this begs the question, who's going to pay the bills? I guess the short answer is someone needs to pay them and pay them on time. Otherwise, your credit rating will suffer. If the bills are in your name, you're responsible for them. Sometimes parties will agree to maintain the status quo with respect to house-related expenses until the home is sold or transferred into one spouse's name. Upon closing, the parties can adjust for post-separation expenses incurred and paid on behalf of the other spouse. And I believe my colleague Michelle is going to speak to that in more detail a little bit later on. Alternatively, the parties may agree that the spouse remaining in the home will assume some or all of the house-related expenses. The interim sharing of finances is decided on a case-by-case basis, depending on the party's means, circumstances, and plans for the home. No one size fits all. We encourage parties to discuss the issues with each other and their lawyers early on to avoid a line-by-line accounting of expenses, expenditures, and reimbursements owed after the fact, as this can be very costly and time-consuming. I think with that, we go over to you, Michelle.
Thanks so much, Brittany. Absolutely. I'm going to talk a little bit about post-separation date adjustments, but this question of who pays the bills and which bills does each party pay, it honestly is one of the things that you really want to get a hold of quickly, because we don't want a situation where one party pays the bills for a year or two and then is owed a very large sum of money afterwards, and it takes the other party by surprise. So it's definitely one of those things, as Brittany, said, she hit the nail on the head. It is not a one size fits all. It is definitely a thing that you need to determine on a case-by-case basis. So what are post-separation date adjustments? Brittany discussed a little bit about them, but they could really be a wide range of things. Basically, all they are payments made by one party that they say the other party needs to contribute to, whether it's 100% or 50%. So some of those things, for instance, are mortgage payments. If a house is in both names and one party is making the mortgage payments and the house is sold 5 months later, who should have to pay for those mortgage payments? Should it be the party who's in the home? Should it be the party who's out of the home, or should it be them jointly? Another one is child support. Sometimes parties do these deals where they'll say, okay, I'll pay all the bills instead of paying you child support. And that could be something that we need to figure out exactly who paid what and how much they should have paid. Bill payments are the number one, though, that we see. And these are just the little things like your cable bill, your internet, your home phone, your, who's paying for the hydro, who's paying for the gas. These are things actually that can cause a lot of trouble later on, and they're relatively minor issues. I know I had a case about 2 or 3 years ago where the parties spent approximately 8 hours, 2 different sessions, going through line by line each bill payment and trying to figure out who owed what. So for instance, if it was a Rogers bill and they had combined cell phones on that Rogers bill together with their cable and internet, one party might owe for the cable and internet and one party might owe for the cell phone bill. And then, of course, if there are any add-ons, if the bills were higher one year or somebody rented a movie one month, it becomes really difficult. So generally, I like to divide the bills as soon as possible. And if it looks like one party is going to be maintaining the home, give them all of the home-related bills to pay early on so that we don't have to do this line-by-line calculation. Another really big one that happens is daycare. So who pays for the kids? I have a number of files right now where we're trying to figure this out. So what happens, for instance, if one party is working and the other is a stay-at-home parent and can take care of the kids? If the party who's working puts the kids on daycare in the days that they are at work, on the times that they have parenting time, who should pay for that? And it's a really detailed and interesting question because there is, again, no one size fits all. You have to look at the facts. You have to look at each family situation. Section 7 expenses also become a difficult thing to wade through. And I know that because of COVID, a lot of kids haven't been doing a lot of extracurriculars right now. And sorry, just to back up, Section 7 expenses are expenses that are over and above what a parent should have to pay from their child support obligation. So if little Billy has a $25 pizza lunch, that's not a Section 7 expense. But let's say that Kathy is a gifted pianist and goes for very specialized lessons, and that was something that the parties had decided on prior to their separation, then that maybe could be a Section 7 expense. So again, these are the things that it is often, it's my practice anyway, and it's often best to deal with them head on and deal with them early. We like to do it by way of 4A meetings where we sit down, we categorize everything that the parties are paying, who's paying for the Section 7s, who's paying for the daycare, who's paying for the bills, and figure out a reasonable way to divide those bills. The other thing that we see a lot, and Brittany and Cindy, jump in here and tell me if you've had to deal with this, is one party removing money from a line of credit or a credit card. Have you had to deal with any of these issues? I see some nodding of heads.
Oh, yes.
I actually got to go ahead, Brittany.
I have, and it gets messy. And
Oh, it's horrible. It is absolutely horrible. I actually had to deal with this just recently where one party took $100,000 out of the line of credit. Luckily, the other lawyer is quite reasonable, but we have situations where that may need to be an emergency motion that is brought if the other lawyer or the other party is being unreasonable. So my practice, and Brittany and Cindy, let me know what your practice is, but my practice is I am fully agreeable to providing any disclosure anyone wants. So if they want every single Rogers receipt, I'll tell my clients to download it. We have a lovely system that allows us to upload documents to the cloud, and the other party and the other lawyer can get it very easily. And so I'll usually create a spreadsheet, an Excel spreadsheet of all the expenses that one party's paid, all the expenses the other party's paid, and who should have paid what and what contribution they should have paid. What about you, Brittany and Cindy? Do you guys have how do you deal with post-separation date adjustments?
try to avoid them as much as possible. I think
I do as well.
Discuss this early on and try to separate the parties' finances and give them financial independence so that you're not having to do this, and you're not having to, if you don't want to have to account for every Tim Hortons visit and every haircut, figure out how finances will be shared, what expenses will be shared, and just simplify so there's less work to do later on.
Absolutely.
Earlier
Cindy,
the
did you
better.
have, oh, sorry, Brittany, go ahead.
Just, I said the earlier the better. The earlier you discuss this and come up with a plan.
I fully agree. What about you, Cindy?
I have to agree with Brittany. And this is also one of the opportunities we can keep our clients' costs a little bit down. We asked them to do the first draft of all of these tables, and to whatever disclosure we are going to provide, we provide all relevant disclosure, relevant and necessary disclosure, and disclosure that's easy to get your hands on. We ask our clients to assemble it so that it's easy, and we can look through it quickly to just verify whatever tables they're going to do. So I ask my clients, do the first draft of this table, let me take a look at it, pass us all of your disclosure, make sure it's nice and organized, and then we vet it, we make sure it's accurate, and we go from there. Like, it's not something that we like to, it's not something that you should be spending a lot of legal money on, because your money can be spent elsewhere. So hopefully we're not at this road, but we try to get our clients, I try to get my clients involved as much as possible to lower their fees. And if we're squabbling over something that's like $200, it's not going to be worth it in the end of the day. So you're going to expect a lot of conversations, especially from us saying like, look, it's not worth the fight. Let's make it a wash. This is $500 or whatever the case is. Look how much time we spent on it. Let's try to figure out a common sense resolution and move forward.
Cindy, I think you and I have a very similar outlook on that. That's great to hear. I know I do the same thing. I let my clients have the first tab of everything. I teach them how to tab things and how the court, like things to be organized. We also give them the draft document so they can actually fill it out themselves. But I actually have some clients who just aren't tech savvy sometimes. So what I'll do for clients who aren't tech savvy is I'll just say, do it in just highlighters. Go to the dollar store, get a pack of colored highlighters, and everything that you think should be yours, put in red. Everything you think should be theirs, put in yellow. Everything you think should be theirs, put in blue. And it's a bit of a low-tech solution to the problem, but still helps to minimize costs.
One thing I would like to add is that at the firm, we have wonderful support. We have a great support team. We have clerks and we have other support professionals who can help us in situations like this so that we can keep your costs down. We can work with you. So if you're not tech savvy and you are doing this highlighter, we can pull in other team members who are at a lower hourly rate to do the first draft or the first skim. So we work with you.
Thanks so much, Cindy. That's absolutely, a great thing to point out. Thank you for that. Okay, so, as everyone said, try to minimize your calculations because they can take a long time. The other thing I like to do is an interim agreement. So if we can come to an agreement on what is going to be each party's responsibility, I like to paper it. I like to put it into a consent so that no one can come back and say they didn't understand or they forgot or, they didn't really comprehend what was supposed to happen. The other thing I like to do early on is I like to have conversations with the other counsel and the other party about freezing the line of credit so that no one gets itchy fingers and either my client or the other client doesn't take steps that could harm the family. Because the problem is, in my example of the $100,000, that once that party has taken the money, the interest on that is owed immediately. So it now becomes the other party's responsibility to pay for the interest on that $100,000 that they've taken out. And they may not realize the financial impact that that's going to have, especially with the Bank of Canada raising interest rates just last week. And we can assume that they're going to continue to raise interest rates for the next little bit. The other thing I really like, ladies, and I don't know if you do this, is I don't know if you've ever seen parties where you get these joint accounts and then one party goes to KFC or Tim Hortons or, just uses the bank account for just these really tiny, frivolous, small expenses. And at the end of the day, you're fighting over, well, was this mom's Tim Hortons coffee for $2 or was this dad's Tim Hortons coffee for $2? So what I do in my practice is if we cannot agree on exactly how to deal with those little expenses, I would say to each party, you each take a certain amount of dollars out at the beginning of the month, a couple $200 or something like that, put it into your own account, and all those tiny little expenses come from there. And that's just another great way to minimize the issues later on and also minimize your court costs. Okay, so moving on to post-separation increases in market value, to share or not to share. That is, I think, the biggest question today, especially given the state of our market. Cindy, you live in Toronto, right? Yeah, I live in Toronto. Brittany, you're in Whitby?
Whitby, Oshawa.
Whitby, Oshawa. I don't know about you ladies, but I can tell you that house prices in my area have gone up about 20% in the last 4 or 5 months. What about you, Brittany? What have you been seeing out in Whitby?
Yeah, it's absolutely insane.
Thank you. Yeah, it absolutely is. I know as far as Bowmanville prices are just skyrocketing. So, The answer, I wish it were easy. It's not easy. It really depends on who owns the home, who's paying for everything, and what happens after date of separation. So in most cases, most parties own the home jointly. And we're talking about married parties who purchased a home prior to separation. They separated, say, in 2021, and in 2022, the value of the home has gone up 20%. Well, the answer is if they sell the home, then the value is going to be shared equally. We will have to deal with those post-separation date adjustments. So maybe one party paid for the mortgage while the other party paid for daycare, but otherwise it should be shared equally. If the home is in one party's name, then there are arguments that the non-ownership party can make as to whether or not the value of that home should be divided equally. And it really just depends on the circumstances, who's paying for what, kids, who's living there, and the reason why the house was put in one party's name alone. I think the more interesting question is what happens if the house decreases in value over that time? And quite luckily, we haven't really seen this in the 12 years I've been practicing. Brittany, I know you worked out on the East Coast for a while. Did you guys see any decreases in home prices at any point in the last couple of years?
I haven't encountered that situation.
So maybe we're, lucky or unlucky that we haven't encountered it, but so far decreases, again, it's an argument to be made. I'm sure the party who's in the home would want the decrease shared, while the party who's not in the home would want the decrease to be borne solely by the party who's in the home. And that would be an argument you'd have to make. It also really would depend on how much the home decreased. Again, in this climate, we don't expect that homes really will decrease. Okay. So I think this is a good time for another poll. Shannon, would you mind launching the next one for us? Okay. What happens if I leave the home? Do I abandon all claims to it? And some of the options are yes, all claims of ownership. Yes, only your right to occupy the home. No, or it depends on how the title is registered. So that's a really interesting one. Brittany, do you have any thoughts on this? Oh, wait, I shouldn't ask you, Brittany. You're actually going to present on this. Cindy, Cindy, do you have any thoughts on this?
Sorry, that's actually one of the questions that we'll be answering at the end. So if I leave the home, do I abandon all claims to it? It is a complicated, there's a lot of factors involved in that. So are you on title? Are you not on title? Did you move to preserve your rights on the interim? So I'll be talking about this at the end of the presentation for example, when I talk about limitation periods, and I'll be touching upon preserving your rights on the interim.
Excellent. I cannot wait for that. Okay, Shannon, let's see how everyone voted. So the majority of you think that the answer is no, 60%. We have 29% who says it depends on how the title is registered, and about 12% say one of the first two. So Brittany, I think you're the next. Yeah, you're going to present. Why don't you tell us a little bit about nesting agreements and the home?
Perfect. Thank you, Michelle. Yeah, we're going to shift gears a little bit, talk about this, and then come back to the issue of what happens if you leave the home. But for now, we're going to talk about returning to the home or remaining in the home. One way that parents may decide to conduct themselves is to enter into a nesting agreement, and that's appropriately titled because that's basically a way of living that allows the children to remain in the family home. And then the parents take turns spending time with the children in the home. This type of arrangement can help minimize disruption to the children, and it may help them adapt to the changes that inevitably come with separation and divorce. Some parents find this arrangement really convenient because it removes the need to send things back and forth between households. So think school bags, clothes, baby items, and the children are in a comfortable and familiar environment. Others may find it unsuitable because it doesn't always afford the parties enough freedom and distance from one another. Nesting, it's practical where the parties have alternate living arrangements. They may share an off-site residence or stay with friends and family. There's really no set approach. When assessing where and how to live, the best interests of the children should always prevail. If you're having trouble figuring out what type of living arrangement is appropriate moving forward, you may wish to speak with a family professional or a lawyer to find an approach that works best for you and your family. I should mention that our firm includes licensed social workers and lawyers, both who are always ready to assist you in crafting a parenting plan and figuring out these types of issues. Lastly, is notice required? If you're thinking about leaving the home, you cannot come and go as you please. If a party decides to leave the matrimonial home, there may be reasons that you need to return. For example, to pick up belongings or check on the house or to exercise parenting time. But you must provide notice before returning. Reasonable notice is case dependent. Basically, you can't show up unannounced, and you should try to respect one another's privacy and their independence.
Thanks so much, Brittany. Actually, that ties in really well. There is a question from an audience member. Basically, to summarize it, there's a matrimonial home owned by both parties. They're married with with kids. One person moves out after 2 years of separation. Can this person move back in at any time? And if not, can they be stopped by the other spouse? What are your thoughts on this?
Is that in the question and answer, or is that?
Yes, it's in the question and answer. So basically, if somebody moves out after 2 years, somebody moves out after 2 years, can they come back?
Ooh, I'm thinking the other party might not be okay with that. If they're both parties in agreement, sure. Otherwise, no, you've been gone for 2 years. You have to figure something out.
I agree. And we see this happen all the time, right? Especially in protracted litigation cases where a party moves out, especially if there have been any domestic violence issues, and then they want to move back in later. And likely what will happen, if let's say my client didn't want the other party to move back in, is we'd bring a motion to the court and the court would make the decision. And as Brittany said, there's so much that you need to consider. You need to consider this specific family and what has happened. But generally, the courts will say that if you've left for 2 years, unless there are extenuating circumstances, then you shouldn't be allowed to be back in the house. Excellent. Okay, so I think, sorry, Brittany, did I cut you off or are you finished with that slide?
No, all done with that one.
Thank you so much. Shannon, would you mind launching the next poll? Can I change the locks? So again, I get this question at least once a month. I don't know about you ladies. Yeah, it seems to be a pretty popular one. So options are yes, no, only if you have a court order. Yes, if your lawyer says it's okay, or it depends on the ownership of the home. I don't know, it'll be really interesting to see what people say about this because I think there are a lot of misconceptions from people who call in to me. People seem to have very strong views on this, and I'm not quite sure where it comes from. Maybe TV, maybe the media, maybe movies, maybe that's where it comes from. All right, so 13% say yes, 13% say no, 48% say if you have a court order, 8% say yes if your lawyer says it's okay. I wish we had those magical powers, a magical wand where we could make everything, just make decisions for our clients. That would be great. Or it depends on ownership of the home. Excellent. Brittany, do you mind giving us your thoughts on this?
Absolutely. Because both spouses have an equal right to possession of the home, one spouse cannot lock the other out or refuse to let them in without an agreement or court order. I appreciate there may be situations of urgency, circumstances where a spouse feels the need to change the locks out of fear for their safety and the safety of their children. In these cases, you should contact a lawyer right away to explore options for protecting you and your children. One of these options may be applying to the court for exclusive possession. A court can make an order for exclusive possession of the matrimonial home under the Family Law Act. These are usually temporary until a trial or agreement can finally settle the matters. When making an order for exclusive possession of the home, the court will consider the best interests of the children as paramount, along with the financial position of the parties and any instances of domestic violence affecting the safety and well-being of all parties involved. The courts can build into that exclusive possession order the right of a party to change the locks. So it's important to take steps to learn about your rights and obligations before acting on them where possible. Speak to a lawyer as soon as possible. Finally, something to keep in mind: if you voluntarily leave the home, you may abandon your rights to possession of the home and its contents. You will still have ownership of the property and you can seek division. But if you intend to leave the home permanently, you should take steps to ensure your property will be preserved and taken care of until its eventual division. If you intend to leave the home for a short period of time only, I would encourage you to make this known so that your absence is not construed as abandonment. Thank you.
Thanks so much. One thing I think we should talk about as well is if you have a lawyer, you can actually bring an urgent motion without notice if there are really good, valid reasons for changing the locks. And unfortunately, I've had to do this in a number of cases. And the reason you do it without notice is so that the other party doesn't retaliate. So for instance, I have a case where one party has possibly been vandalizing the home and scaring the other party. And so we may have to bring a motion without the other party's notice to change the locks and to have a restraining order against him so that the vandalism acts stop. Have you ever had to do this, Cindy? Bring one of these urgent motions without notice?
I've had to defend against them a couple of times.
That's great. Let's hear your perspective on defending against them.
So when this happens, you're given a short time frame to respond, because these are done, of course, without the precipitation of the opposing party. So you're going to look at a quick turnaround time of around like maybe a week or less than that. So if you receive this type of order, you're going to be urgently looking for a lawyer, and the lawyer is going to have to get up to speed very quickly. So he or she is going to be talking to you about, well, what does this, where are you living? What happened? What evidence do you have? What can we decide on an interim basis to get the family past this impasse, past this point in time, to move you guys towards a final resolution of everything? Because if someone's going to be bringing an exclusive possession order or a restraining order against you and it's granted, chances are you're not going to want to go back to that property because of the fear that you have that, they're going to try to do this again. And what if there's criminal charges and now you're going to be dealing with a family law matter and a criminal matter? You don't want to be in that position. That's very expensive, and that adds complexities to your file that, we want to avoid. So in this short turnaround time, we're going to be taking instructions from you. You're going to be gathering your evidence, and we're going to try to figure out what's the best solution. Because maybe the best thing is we don't want you back in that home for your own safety. Let's figure out something temporary. Maybe let's talk about, we have to address the finances. Like what can the family afford in this interim basis? And one of the things that we're going to talk about, which is my next slide, is occupation rent. Is this something that we have to raise? Is this something that's going to be tallied at the end? Who's going to be paying for the mortgage, the expenses? Now, the party who was kicked out, they have to pay their own rent, maybe. So it becomes complex, but the focus in that type of situation is to do what's best for you and for your ultimate goals moving forward.
Absolutely, Cindy. All great points. And obviously, if there are children involved, that's going to be a huge impact as well on the decision about, what's going to happen with the home. So thanks, Cindy. Do you want to tell us a little bit more about occupation rent?
Oh, yes. No, thank you. So occupation rent is the rent that you may receive from a party who is staying in your home. So think of it as, in other words, they're paying you rent for the use of your asset. Occupation rent is not an automatic payment that you'll receive or an automatic payment that is owed, but it can be thought of, it can be a credit that is tallied at the end. So the analysis of how much and for how long occupation rent is owed is a balancing act. So we're going to look at, and the courts will look at, what are the means and needs of the parties and what is their conduct? So for example, if there is a history of family violence and one party had to flee the home, or there's cases, or there's a restraining order present, is child support being paid? Is spousal support being paid? Was there a delay in bringing your claim? Or where are the children living? These factors play into whether or not the courts will allow you to bring forward a claim for occupation rent. Because occupation rent, it has to be fair and reasonable in the circumstances. So say, for example, I'm just thinking something off the top of my head. The party who is in the home, they brought an emergency restraining order because of threats of abuse or actual abuse that they suffered. And they were granted an exclusive possession order, and they, due to the children, they because they were habitually a stay-at-home parent, they do not have the funds they're in need of child and spousal support. And because of the emotions in the family, because of what happened and all the emotions involved, the other party who's excluded from this property decides not only, of course, they're upset, but now they're going to add a level of financial burden to the situation. So they're not going to be paying support. They're not going to be paying anything towards the home. They are going to allow this property to go, maybe the mortgage to go into arrears. And the party who's left behind has to scramble to figure out how to keep the property afloat. So I'm not saying that in situations like this, the party who is ousted must pay for all of these expenses, but we're going to look at their conduct. The court is going to look at their conduct. Have they been acting reasonably? Because there's very rare can someone afford, child, spousal, and proper and maintenance of the property. But are they acting reasonably? Are they giving at least something to help keep the family afloat? So in situations like this, you can see the balancing act that the courts are going to do. So in practice, what I'm getting at is occupation rent is difficult to advance given all the factors that the court has to weigh. But it's certainly something that will be on the table. We're going to be talking to you about it. We're going to be coaching you or talking to you about, like, well, look, this happened, but let's make sure you're in the best position to get every possible credit available to you in the future. So when it comes down to property, if you are ousted from the property, we want to make sure you're in the best possible position to advance a claim for occupation rent. So now on to my next slide, which I know we've been receiving a little bit of questions on, is the limitation period. And I'm going to add also preserving your rights. So the courts expect the parties to deal with their issues in a timely manner. Okay, and this is because due to the availability of evidence, the availability of witnesses, and the expectation that people have that, you are finally behind this. You're finally like this, your history, things are done. There's finality here. I can move on. So according to the Family Law Act, you must bring forward a claim with respect to property within 6 years from your date of separation or 2 years from the date of your divorce, whichever occurs first. Now, if you fail to advance your claim within these time periods, the court may say you are out of luck. And I stress may. Okay, there are caveats to this. For example, if the property that you want to deal with is jointly owned, okay, then that's when these limitation periods do not necessarily apply because you are a jointly owned owner of this property. However, we still want you to deal with things in a timely manner because, as Michelle and Brittany were talking about, we don't want to be in a situation where we're dealing with 10 years of credits, for example, that we have to tally, that the other person's going to say, well, look, yeah, it's joint, the property is jointly held, but I carried this property, I renovated it, I maintained it for the last 10 years, I want a credit. And when we take a look, that's expensive to look through, that's expensive to analyze, and who knows at the end of the day how much money we're actually talking about here, versus if you were to deal with this early on, that type of analysis would be much more straightforward. Now, I know that another question has come forward in the Q&A is, how does COVID impact this? Well, the takeaway that I want you to have from this presentation is, if you have a claim like this, address it in a timely manner. Okay, so the courts do allow, there is some discretion to extend limitation periods, some discretion. But to get to that point, you are going to be, it could be done through negotiation, but you're going to have to be signing certain agreements. The parties are going to have to be signing certain agreements that they confirm that they will be preserving their rights, or you're in a court process. And the first step would be, you're going to be bringing a motion to asking the judge to extend the limitation period before you get into all the other issues. So that's going to be a major roadblock, and that's going to be an expensive roadblock if you're in that type of situation where you're going to be pleading with the court, Your Honor, I had a valid reason not to bring forward my claim within the limitation periods. And if you allow me to do this, it will be shown that, there's no prejudice to the other party to allow this to proceed. And I do have a valid claim. So, there is some discretion there in the courts. It's on a case-by-case basis. We'll have to know the reason why. It has to be a good reason why. And it is an expensive endeavor if you're in that type of position, because of the evidence that you will need to advance to convince the court to look past this limitation period, given the fact that, parties have the right to move on with their lives. Okay, so now, like I said before, if you ever find yourself in a situation like this, and the takeaway that I want you to have from this presentation is, do not wait. Get legal advice on your side. And if you get us involved early on, we work with you to help to preserve your rights while we are negotiating. So we can talk to you about things. For example, there are certain things you can register on title of properties to preserve your rights, and to also signify to other people that, hey, or if the property is about to be sold, like, hey, you cannot, there's an issue with respect to this property, you're going to need someone else's consent, or it prevents that person who's trying to sell it from even selling it. So we would talk to you about those options if you come and get us involved early on. And also, we can address the whole issue of credits, and we can get you working on these tables and collecting the information, so it doesn't become as costly as an endeavor later on, if you were to wait like 10 years or 5 years from the date of separation, or 10 or 8 years or whatever like that. So these tables won't be as daunting. The other thing we can talk to you about is, we'll ask you, how is title to this property being held? If it's held in joint tenants, what that means is that if one of the titled owners passes away, their portion of the property automatically goes to the other joint tenant owner. Okay, we would talk to you about changing that title to tenants in common. So what that means is that you are still the equal, if it's equal, you are still, your proportions of ownership do not change. What happens is what happens in the event of your death. So when title is held as tenants in common, your portion of the property will go to your estate instead of to the other party. So this is something we can talk to you about to help to preserve your rights. The other thing is that we want to have it on record that, okay, if you had to leave the property, and of course, and if children are involved, we want to start negotiating right away what's going to happen with the kids. What type of access schedule are we talking about? What type of parenting time schedule are we talking about? And have it on record that you are actively pursuing whatever parenting time schedule right away, so that it can't be used against you. Just as my colleague said, it does create a new status quo. So if you're given just every other weekend instead of what you truly want, for example, is equal time parenting, well, we have a record that you were trying and you were negotiating in good faith to try to get that type of parenting time schedule, but the other party has denied you for whatever reason, and we will use that as evidence. If we have to bring a motion, if we have to bring an urgent motion, we will rely on those correspondences to advance your claim. So I believe we are, I'm going to stop right there, and I'm going to pass it on to Shannon to wrap this up. I am sorry.
Thank you so much, Cindy, and thank you, Michelle and Brittany. There's a lot of really great information. Thank you so much for sharing all of your insights. And we just want to thank the audience as well for your participation and sending in your questions. We did have quite a few come in, so we're going to do our best to get through as many as we can in the next few minutes that we have. So first question I have here for our panelists is, should you have a separation agreement in place before leaving the matrimonial home?
I can take this one. It would be lovely if you could, and we would, that would be our ultimate goal, but it generally doesn't happen. A separation agreement takes time. You both have to provide financial disclosure. You may need to get information from the CRA or the banks, and that can take months, unfortunately, and that's out of your hands. So while that would be a wonderful goal to have a separation agreement prior to leaving them at home, it isn't always possible.
Great, thank you, Michelle. So next audience question we have is, does sleeping in separate bedrooms, buying your own food, for example, count as being separated?
I'll take this one. You can definitely be living separate and apart under one roof, so long as you notify the other party that the relationship has terminated, then you'll be considered legally separated. If there's any question about whether or not you are separated, the court will look at a number of different factors. For example, whether you share a bedroom, whether you're having sexual relations, prepare and eat meals together, how you represent yourselves to the world, you attend social events together as a couple, division of labor, finances, sharing the finances, lots of different factors. But definitely to answer the question, if you're sleeping in separate rooms, buying your own food, living as separate and apart under one roof, then you are considered to be separated.
Thank you, Brittany. I think we have time for one last question just before we wrap things up here. So last question is, can you explain the key differences and pros and cons of a collaborative approach and a litigation approach, to family law dispute resolution?
If you don't mind, ladies, I'll take this one. So the reason I'm taking this one is because I'm actually on the board of the Durham Collaborative Association, so I can tell you a little bit about it. Collaborative and litigation are night and day difference. A litigation file is a adversarial process where the parties are not sharing information. Sorry, they're fighting against one another, and the ultimate decision maker is a judge. In a collaborative file, the parties are working together for the common good. So, the parties sign something called a participation agreement, which says that they're going to provide all the information. They're not going to play games. They're not going to do this in an adversarial process. And if they do, then their lawyers must withdraw. For instance, if I, as a collaborative lawyer, find out that my client is hiding an account with $100,000 in it, I must withdraw my representation of that client because they are not following the collaborative principles. Generally, I find collaborative to be much more family focused, much more child focused, and also, most important, much more creative. We can, come up with solutions that work for both parties. It may not be both parties' number one resolution, but it would be something that they can both live with and both be happy with. So the other thing with collaborative is that we do allow for third-party professionals to help. And these third-party professionals, such as the family professional, can actually stay on with the parties even after the lawyers are done. So for instance, if we have parties with really young children, what may be good for the kids at ages 2 and 5 may not be good for them when they're 12 and 15. So you don't have to re-engage with the lawyers. You can go back to the family professional who can help you modify the parenting arrangement as the kids get older. Thanks, Shannon.
Thank you so much, Michelle. So that's all the time that we have. I just want to thank our panelists again, once again, very insightful. We hope that you have all found this content helpful and have some good takeaways from today's presentation. And we just want to thank you all again for joining us today and for all of your participation. We really appreciate your support. And I just want to mention again, just to keep an eye out for a follow-up email tomorrow. We'll be providing links to helpful resources on today's topic. And again, that'll come out tomorrow. And if you do have any general questions about our virtual event series or any comments for our team, please feel free to reach out to me at shannon@russellalexander.com. There will also be a survey that pops up in your browser following the webinar. So please, if you have the time, we welcome and appreciate any feedback you have, as it helps us to continue to grow and develop our program. And one of the questions on the survey will be to share your thoughts on topics you would like to see our team discuss in future presentations. So please let us know your ideas. We love hearing from our audience. And just to let everyone know, for those of you who are new to this series, we do host these events bi-weekly. And our next webinar is on Wednesday, March 23rd, which will be Zoom Divorce for Clients and the Modern Lawyer. And you can now register for that. So I'll be including the link to that in tomorrow's follow-up email, as well as some more of our upcoming presentations. So again, we just want to thank all of you for joining us today, and we hope you have a great rest of your day.
Thanks again, everyone. Have a lovely day.
Thank you.
Bye-bye.